Good evening. My name is John Milburn, and this is LAWS 11057 Introduction to Law. We're into the 5th week of term, and this week we're concentrating on legal research. But before we do, just a few things about assessment work. Those of you that submitted your first work, your portfolio, should now have received your feedback. If you haven't got your feedback, please let me know and I'll ensure that you receive that. If you haven't submitted your work, then it's not too late to do so. You will suffer 5% per day for each day of late submission, but unlike other assessments that I set, there is no cutoff. Although if you, of course, multiply 20 days by 5%, then of course that 20 days becomes the effective cutoff. Hope that makes sense. But this is a worthwhile exercise. Those of you who completed the task, just a quick poll, yes or no, in the chat facility to get you warmed up. Did you find it easy? Yes. Difficult? Easy or not? Yes or no? Did you find it easy? Yes or no? Yep. Okay. Overwhelmingly, the answer is yes. So much so that it's almost embarrassing to give 20% of your first mark to a task of that nature. But the idea is to get you moving, get you into the routine of submitting work, submitting it on time, and you'll see from the feedback that, as I promised to you, I wasn't all that concerned with what you've actually done or what you intend to do, but it was more a case of the technology, the professional presentation, getting the basics right, completing each one of the tasks that we set for you, and if there was going to be an area where I looked more critically at the work than others, it was to do with the ethos statement and some commentary in relation to issues around plagiarism. So part of the exercise is to give you some due warning about the requirements to ensure that what you present is your own work, or what you present is attributed appropriately to other people. So the subtext of that is, make sure that you now start to concentrate on the AGLC. So whilst I wasn't really concerned about footnote referencing and proper referencing in the first assessment, from now on I will be. So make sure that you have your ready reckoner, your guide to the AGLC. Make sure that you look carefully at the way in which authors and judges footnote the reference material. Sometimes you'll find they don't do it in accordance with AGLC, so if in doubt, go with the AGLC and learn from osmosis. So be particularly concerned about footnote referencing. There was a question about word count. It's a good question. If you quote material from a case or legislation or from some secondary source and you put it into the body of your work that you present to me, then that quotation does form part of your word count. If you have material in your footnote, it won't be part of the word count. But don't be tempted to put great chunks of material in the footnote as a way of getting around that issue. Certainly other unit coordinators may take a dim view on that. Now, can I just have a quick yes or no? Do we feel confident about the basics of referencing and AGLC? Yes or no? Yes, semi, a little, still learning, 50-50, sort of. So whereas I think we've got the idea of the portfolio nailed, we need to work a little on AGLC. So question is there someone we can go for feedback? Yes, if you have an issue, if you're not sure, ask, as you normally should do, any question through Q&A. I'll respond, and your colleagues are likely to respond as well, quite often before I do. So studiosity, says Timothy Faint. That's not a bad idea either. So the best feedback, best way to look is to find the ready reckoner, the quick guide to the AGLC, and look at what others do. But if you're stuck, ask some questions. Now, can I just ask another very quick question? Does everyone know how to insert a footnote using, say, the Word program, for the text side of it? It's really, really simple. So yes or no, lots of yeses coming through. If you're watching this as a recorded session and your answer to is no to any of these questions, then please look into it or ask for help. Do so through the Q&A session. Next question, how are we going with legal research? Are we feeling on top of this? Are we starting? So again, yes or no. How do we feel about legal research? No, getting there. Hard to read sometimes, but getting there. Not really. So that's an area where we need to concentrate upon. And that works in very neatly with your second assessment piece. So tonight we're dealing with legal research. What you will find invariably is that of the massive quantities of material that's available to you in terms of legal research, you'll develop your own preferences and shortcuts. So we each have our own style when it comes to legal research. So that means that you need to consider your portfolio. It's now, can I ask you this question? And I'm sorry I'm asking you a lot of questions, just getting you warmed up. Has everyone looked carefully at the assessment task number 2 that is due on the 17th of January 2019? Yes or no? Have you looked at the task requirements carefully? Oh, I like these answers. Everyone's saying yes. One not yet, but we won't be far away. Briefly. So in light of my stated philosophy to you, I think in week 1, that I would like you to look at what you want to achieve at the end of the unit and work backwards. It's absolutely imperative now that you look at, oh, someone's written half of it. Well done. I like that answer. It's imperative now that you look at the assessment task, you understand what's required of you, and I would ask at least that you prepare some sort of template, somewhere that you can add material as you go. So as you're undertaking your legal research, you think, oh, I like that. I like it for this reason. I like it because of the citator, or I like it because of the way in which case law can be referenced to other decisions, for example, through note-up facilities, or shepherdizing as sometimes it's called. Then make a note of that and include it in your toolkit. So the toolkit is something like the portfolio that becomes yours. There is, unlike the portfolio, there is no prescribed template. So you'll note that in the material we've said, here's the task description. Here's what we want you to build. Here are some videos prepared by Associate Professor Scott Beattie, who developed this program. And we want you to submit your work, but you'll note that there's no template. So this is your opportunity for creativity and to determine what's the best way for you to prepare a toolkit. So you need to adopt your own approach to legal problem solving and create your toolkit. Now, are there any questions about the second task due on the 17th of January, what's required of you, or where I want you to start and how I want you to start to build this program now? And you should be starting to write this. Any questions before I move on? Okay, good. Now, while we're at it, we'll just have a look at the third task, which is the briefing paper. You won't know what the exact briefing paper is at this stage, but I've just added this evening a copy of the briefing paper that was the requirement for term 2 of this subject last year. I think I'd previously provided you with the briefing paper for term 3. So again, sorry, a lot of yes or no's tonight. Has everyone looked at the briefing paper for term 3 last year, just as a guide to what they need to do? Yes, no, no, no. We're getting a few no's. All right. So please do that. And where would you find the briefing paper for last year? I know that Moodle under assessment. Thank you, Rhonda. Yep. So there was one. Now there's 2. So if you've looked at last year's paper for term 3, then please go back, revisit, and have a look at term 2 paper as well. What you will notice here is, and I'd like you to do that now, not literally now, but now, this week, in the next few days, because as you're undertaking your legal research, I want you to answer these questions. And you'll see that the briefing paper that I set for term 2 last year is very different to the one that I set for term 3. Term 2 was a problem-solving issue. It was to do with a contract dispute. Term 3 was probably much easier and had specific questions and some short essays. But both give you an idea as the sort of thing that I expect you to be able to complete by the end of this unit. So as you're doing your legal research, please have those assessment pieces. This is the briefing paper, the final online paper, if you like, for both terms, ready to go and start to answer the questions. If you find that you're stuck, you can't answer the question, then ask through Q&A, and we don't really want to give you the answer, but the idea is that we give you the tools to find the answer. When you look at the assessment piece from term 2 last year, you may say, well, this is tough. We didn't do contract law. How am we supposed to answer a contract law question? It really comes down to this, that over this week and the next few weeks, the task that I ask you to commit to undertaking is to learn the way to undertake legal research so that you know how to find the answer. I don't expect you to necessarily to know the answer. And I think I said that in week 1. You will never know all the law, but it's important that you can think like a lawyer, that you develop the process of legal reasoning, you understand primary sources of law and secondary sources of law, you know the hierarchy of how legislation is going to trump, for want of a better term, case law. You understand the different hierarchies in the court system so that you can then understand how everything fits together and then where to find the law. So it's critically important that you start to learn now how to find the law. Quick exercise. Can anyone tell me how they might find a decision which is in the from the Queensland reports? Now, the Queensland reports are the authorised reports from the Court of Appeal or the Supreme Court of Queensland or even District Court. So where would you go to find the Queensland reports? Looking for an answer? No one yet? All right, so we're getting Queensland Supreme Court website, Parliament website, Hansard, Supreme Court website library, Queensland Parliament. We're getting a bit of a mixture. What I'd suggest you do, and please look at this now, not literally now, but have a look at www.queenslandjudgments.com.au. This is a very important website because, and it was only introduced this year as a free website, it provides you access to the authorised Queensland reports, and it's a complete set of reported and also unreported decisions of the Queensland Supreme Court and Court of Appeal, and it provides other information such as the commentary about the Uniform Civil Procedure Rules. So when you're looking for Queensland reports, look at the Queensland Judgments website. You might be able to find them from other sources as well. Ostley was one other suggestion. Now that begs the question, what do we mean by an authorised report and something that is not authorised? Anyone able to tell me that? I'll give you a hint, it's a bit arbitrary. So what it is not the media, no. Or approved for public viewing, yeah. Provided by the courts, yeah. I think that's probably the best answer. So thank you to Sandra for that. Each of the courts have, if you like, the official version of their decisions. Now, it may be that the same case is reported in a number of sources and it may have a different citation. So you may find that a decision in the High Court has a CLR reference or a HCA reference or some other reference. It's the same case, but it's a different way of reporting. It's a different service that reports it. It's a bit like getting the news from Channel 7 or 9 of the ABC or whatever, you know, you're getting the same information but presented in a slightly different way. So for each of the jurisdictions, we have the approved reports, and in Queensland, that is the Queensland reports. In the Commonwealth, it's the Commonwealth law reports. In the federal, it's the federal law reports. So just be aware that when you're creating your toolkit, that I would expect you to have some idea of what we mean by the authorised versus the unauthorised reports and how to access that material. So you now know how to access that. For Queensland, you can pop that into your toolkit. So, and the law changes in this regard. So can I refer you to this case? It's to do with the hierarchy and some comments made by the High Court in relation to the courts of appeal in states and territories having consideration or in fact being bound by courts of other states and territories. The decision I'm referring to is FARAH, F-A-R-A-H, Constructions, Pty Ltd, against SAY, S-A-Y, new word, D, D-E-E, Pty Ltd. The citation I'll give you is the 2007 HCA 22, and in that case, the High Court said that courts of appeals are bound to follow decisions of other courts in other states or territories. The previous view was that courts of appeal in the state or territory are not bound to follow any other decision from another court of appeal from a different state or territory. And arguably, even within the own state, courts of appeal are not bound by a previous courts of appeal decision. So there's some subtleties in this, is really the point that I'm trying to make. But that's a good case to refer to if you're trying to better understand or explain this concept of precedent and within the context of the court hierarchy. Okay. Now, on the buzzers, please. Two sources of obtaining... Oh, good question from Rhonda. When we get the case to look at, do we need to read the whole case? And it's not a silly question. No, generally you wouldn't read the whole case. It'll drive you crazy. You can, in some circumstances, read the whole case, but the important thing is that you glean something from it. So when you're reading a case, typically there'll be some sort of introduction or head note. In the High Court, they have their case summaries, and that's a great way to look at material. So in your toolkit, you'll need to know how to access the court summaries in the High Court. You won't get that in all the courts, and many courts, it's a matter of speed reading, trying to identify the important part. Can I just say that Jade Barnett is a great resource in this regard. If I'm looking to find the important parts of a case, I'll often bypass the authorised reports, go to Jade, and I look then to see where there is the most activity, because in a Jade court report, it will show you where individual sentences or phrases have been referred to by other decisions or where that case refers to previous decisions. I hope that makes sense. If you haven't been to look at Jade Barnett, please do so now and build that into your program. Now, Lockie says, I read Project Blue Sky versus the ABA, two totally different ways earlier, and the brain broke. Yes, it can happen that way. And that's with Project Blue Sky, for example, those of you doing statutory interpretation, you're probably more looking at the case, not so much for the facts, but for the principles behind it. All right, now can you hear me, Gareth? You missed that? So is my microphone is just cutting out. Sorry, I didn't hit the mute button. It must be my bandwidth issue. Yeah, connection is unstable. I'm just going to stop the video and hopefully at least you'll be able to hear me more clearly. So what I was saying is that when you're looking at a case, consider Jade Barnett because it has an excellent resource in terms of giving you an indication of where that section of the case, paragraph or sentence or even word, has been referred to in other decisions. Okay, here's your next quiz. If you're looking for federal legislation, where are the two places that you might first consider going to look for this? Federal legislation, the Family Law Act. So very quick off the buzzer, we have legislation.gov.au, OSLI, the federal legislation website. Excellent, very good answers. There are other places that you can go, but I've got to confess they're the two that I normally go to first up. Make sure that you have bookmarks or you have links in your portfolio, in your toolkit to these important websites. And remember, it's not so much for me in marking, but for you in actually using this, because you'll need the toolkit seriously for your third assessment. And when you read the second assessment, no, when you read the final assessment for term 2 last year, you'll get an idea of how important it is to know this, your way around legal research very quickly. Okay, case law. Where would you look for a Tasmanian Supreme Court decision, for example? Any thoughts? We're getting a vote for OSLI. Always a good way to start. Any others? OSLI. You could look in Jade. You could look in, well, there we go. www.supremecourt.tas.gov.au decisions. Okay, Lexis, says Gareth. So there's a few different sources, but don't restrict yourself to just Queensland or the Commonwealth, and do put in an emphasis on your own state or territory as you see fit. All right, now quick yes or no. Have you looked at some of the legal research videos, some of mine, for example, that are on the Moodle website, are accessible via Moodle? Yes, have you looked? Yes, we're starting to see a few, yes. Good. Now we should have everyone looking at those. So, and bear in mind that they are maybe 12 months old and things do change. So some of the material may already be dated and you can draw from that, but make sure that you cross-reference it, make sure you check it out and have your own ways of doing things. Certainly the the Supreme Court Library of Queensland is excellent. Now, can anyone tell me if they wanted to find some commentary about what a judge might describe to a jury as what is meant by, say, self-defense, where would you find that and what do you call it? Quick guide. Where would you find the actual commentary that a judge might consider and refer to in explaining self-defense to a jury? All pretty silent. Have I stumped you on that one? All right, so firstly, where would you find the law specifically about self-defense? If you wanted to know something about, if you wanted to explain something about self-defense, where would you look? So we're getting some answers coming through now. Acts Interpretation Act, the Criminal Code Act, the Criminal Act, criminal, maybe. Yep. Crimes Act, says Tuna. Sentencing Act. All right, so a good array of questions there. And I think everyone gave a response saying legislation. Always a good start. I like your mindset. When you need to consider what is the legal position, it's always a good idea to consider legislation first. Self-defense, is it state or is it federal? Or is it both? What do we say? State, federal, or both? We're getting some votes in now. Both. Yep, I agree with that. So in the Queensland context, usually it would be in the Commonwealth, in the Queensland Criminal Code that you'd look. So have a look in the legislation first. So to do that, you need to know how to find the legislation and then have an easy way of working your way through legislation. You can use a search facility if you like. Does everyone know how to use search facilities in, say, Austlii or Jade? We're getting some yes? All right, good. Getting there. So you need to Control F. Thank you, Rhonda. So we do need you do need to be able to search in an efficient manner. Otherwise, you'll run out of time. You'll get bogged down. So as part of your toolkit for the second assessment, please tell me about the way you undertake search facilities or use search facilities when you're looking at case law or legislation. Right, self-defence. We'll come back to that. You found the relevant section in the Queensland Criminal Code. Actually, would everyone be able to find the criminal code? I'm sure you would. But just if you're watching this as a recorded session or when the session is finished, just make a note to yourself to see how quickly it would take you to find the section that relates to self-defence in the Queensland Criminal Code. Just for example, I won't get you to do it now, but please make sure that you check that out. If you struggle, if you're finding it's difficult to find, then we need to work on the technique a bit. All right, so you found self-defence, but the question that I posed to you was this. Where would you find the commentary that a judge might use when describing self-defence, the legal mechanisms and definition, if you like, of self-defence to a jury? Is there anywhere other than the legislation? Still no? All right. Have a look at bench books. It's BECHBOOKS. For example, look at the bench books for Queensland. Then find where to access those and have those things catalogued in your toolkit. Have a look at the array of material that's there and you'll get an idea of the quality of material that's available to you free of charge through various websites. So please make sure that you know how to access bench books. So what you need to do, bench, yes, Rhonda, bench as in the bench where a judge sits. So the bench books are actually a resource for judges, but they make them publicly available, which is very helpful. Now, when you're preparing your toolkit within the context of legal research, it's very important that you understand, adopt, and document your research methodology. I want to have you understand how you go about this process in a methodical kind of manner. So here are some things that you need to ask yourself. Firstly, within the heading of context, where do you begin? These are the questions that you ask yourself. Where do you begin when approaching a legal problem? So bear in mind that legal research is tailored to answering a legal problem, which is where I want you to look at the take-home papers from last year, because particularly the second one, term 2, is a legal problem. And you've got to think, well, where do you begin when approaching a legal problem? We've already talked, not Google. No, we don't like, I've got nothing wrong with Google, but it's not a great way to start legal research. Okay, so when you're looking at a legal problem, before you even start your legal research, you need to think about your legal problem-solving skills. And a good way of doing it is to consider the IRAC methodology to determine the issues, the rules, the application, the conclusion. But the point about that is that before you look to the rules, you've got to identify the issues, don't you? There's no point, for example, in looking up some research on environmental law when the issues really relate to contract law. I hope that makes sense. It might be obvious, but you need to build that into your methodology. Once you've done that, think about what databases are available to you. Which ones are the free ones? Which ones are the paid ones? What have you got available to you for the library? Now, to answer that, you've really got to do some exploring, and you must have a look at the legal library that we have for you at CQU. It is excellent as a resource. Once you've determined the databases, then you start to think about your search strategy, and then you can start to answer the question. All right, so broadly, your legal research then, if that first part is really the context. Once you've determined the context, then you're really looking at the either legislation or case law, I think, to start with. Now, a lot of people would say, yes, but don't you look at textbooks first? I don't. I look at legislation, case law, and I use textbooks as a reference point to confirm or otherwise what I've already discovered. If I'm stuck or I want an angle, then I might look at textbooks, but generally I'll look at legislation first. So this is just an idea of my methodology. Now, that's all very well, but you've then got to say, well, where do I find this legislation? And where do I find regulations? And how do the two work in together? So, for example, if you're researching a problem involving a fisheries dispute or a fisheries prosecution, it may be that you look to the legislation, but more importantly, maybe the regulations. So you've got to understand how to find both and how they fit in with each other. Once you've found something, you then have to cite it appropriately, which means how do you cite, C-I-T-E, cite, material? How do you reference it? Which is the AGLC. Some other questions. How do you make sure your legislation is up to date? Now, if you're dealing with an issue that relates to, say, a prosecution that may be historic, you're dealing with, say, a child sex offence from allegedly occurring in, 1998, then how do you find the relevant law in 1998? And I think by now we probably all know how to find point in time reference to legislation. If you don't, you'll need to do that, but you need to build it into your toolkit because you may make a rookie error by referring to legislation as it is now, when in fact the question calls upon you to look at legislation at an earlier point in time. So the question is, John, will the cases defined and apply be from the material we review? I know you'd love me to say, yes, everything is in the textbook, but I can guarantee it won't be in the textbook. So if you look, for example, at, and I keep saying it, the second assessment from last year, you'll see that we didn't teach it at all. I didn't teach any contract law apart from a few things in passing. So if I do a similar problem this year, it could be family law, it could be consumer law, it might be environmental law, it might be alternative dispute resolution, it might be employment law. So it really doesn't matter. What's important is your ability to research that material. So I'm not looking necessarily for the nuances of it, but I'm looking for your ability to find the material. One of the great advantages of having a take-home paper. You'll need to understand the legislation within context, and in the next couple of weeks we'll be dealing with some statutory interpretation issues. Those of you that have already done statutory interpretation, or you're doing that now, you've got an advantage. But for those that are just doing introduction to law without having done or doing statutory interpretation, we'll deal with that. But it's important that you are able to look at legislation and find out how to read it properly. That is, looking at the whole lot, looking at the headings, getting a feel for it, looking at the objects clauses, the definition clauses, and then narrow down to the specific detail. So you need to build this into your program. So have some aid in the interpretation of legislation is really what I'm getting at. When it comes to legal research, you probably need to know how to find the explanatory note, the explanatory memorandum, and or the second reading speech. So make sure that that is linked in your toolkit. Make sure that you understand and can apply when an act came into effect. So you need to know what causes the act to come into effect, which is the assent. How do we determine the date of assent? That's got to be in your toolkit. Then I mentioned earlier regulations. How do you find this subordinate legislation? How do you find the regulations? What databases do you look at? So I'm sure you'll be able to find these things. Question, in terms of case law, is there any form of explanatory note for cases? No, sometimes you'll find some explanatory notes, some summaries in, say, the High Court, but there's not an explanatory note for cases like there is legislation. There might be some case law, there might be something in a head note, but nothing else. Case law. So you need to know how to find these reports online. You'll need to know how to cite the case. You need to understand the difference between the authorised and the unauthorised versions. We've already talked about that. And you'll need to know how a case note or a head note. And you'll need to know how to read a case. So this involves a bit of speed reading technique, identifying the important parts. You need to understand the difference between a majority opinion or a dissenting judgment, how they might be useful in different ways. And you need to note up a case or shepherdize a case. So you need to find a way of identifying whether a particular case has been referred to by other cases at a later time, and if so, to what extent. It may be, for example, that you've found this really good case from the Queensland Supreme Court single judge decision in 2004, but if you undertook your research more carefully or more thoroughly, you may find that the Court of Appeal overturned the rationale behind that case in a decision 3 years later. So in other words, what was good law is now not good law, it's not reliable law because it's been overturned by a higher court. Okay, I hope I'm not scaring you off. That's not the intention, but the intention is to get you motivated to start working towards the things that you need in your toolkit. So I'm scaring you off just a little. Don't mean to, but enjoy the process because you will find things in you'll find your own style. Now, are there any questions? Because I know I've been doing a lot of talking. And I'm not taking you to many specifics here, I know that. But that's what the legal research videos are that's what they're for. So you can find these things for yourself and some guides on that. All right, questions. What happens if laws are overturned, compensation measures for that? Yes, sometimes there are. Not always, but sometimes there are. Okay, you then need to present your material. You need to put it together. So you need to have a way of presenting your material in a professional manner. And this is where the plain English language skills come into being. You need to speak in a way that is concise, to the point, but easy to read. Now, question here, in the toolkit, is it research based on a case I can think of, or is it a case I'm working on or I'm not aware of? It should be, oh, okay. So the toolkit is the second assessment. So if I talk about the toolkit, I'm really talking about the second assessment. And the toolkit is really just what you develop. It's my shorthand way of saying this is your response, your answer to the second assessment is your toolkit, because the idea is that it's something that works for you and that you will actually use it. I'm encourage you to build on it. It's like the portfolio. It's yours now. I've already marked it. You've got your assessment, you've got your feedback. So now just make it whatever you want it to be. Likewise with the toolkit, prepare something for me to assess, but the main issue is it is something that you use. So it's a personalized toolkit. It's not specific to any particular question, legal question. It's not prepared for me. It's something that works for you. The question is, do we have to explain anything in detail or use flowcharts and then explain the overall process? You've got a fairly strict word count, so just bear in mind that you need to be economical in the way you do that. And you don't need to explain to me a lot of the basics. So, and the question is, how do we get graded on that when it's personalized? Well, here's the good answer. There is an opportunity for people to have a completely different approach and still get top marks, because I appreciate that a very large part of this is subjective. But of course, it's still got to be logical. It needs to be comprehensive. It needs to be accurate, of course. And it needs to be something that I would look at and say, that's different to what I use or how I go about things, but gee, I can really see how that would work. So it's a very practical exercise, this one. And I don't want you to provide me with a theoretical exercise. I want this to be super practical, and I want you to be able to say, when you're dealing with torts law, for example, with Anna, wow, my toolkit really helps me here. I get it. It's a really good way of answering my questions. And if it doesn't, then change your toolkit to make sure it does work. Does that make sense? So it's all got to be different. Question about the word count. I forget what the word count is. Probably 2,000 words. Here, Sandra says 2,000 words. With this exercise, it's a little like the portfolio in that you may well be able to find that you can answer this in less. It may be that others go, wow, I need many more words. So it's just a matter of finding a balance there. Question is, how many types of law do we cover? Well, the idea of the toolkit is that it's supposed to provide you with the basic information that you need, the basic techniques to cover any field of law. And that's why in the third assessment, it'll be just random in terms of what type of law I'm asking you to provide a response to. I hope that makes sense. Just on word counts, do we get a certain percentage we can go over or lower? That's a really good question. For me, I tend to be a little more liberal than others. It's not to say I'm right and others are wrong, quite the opposite. It's just the way we approach it. But if you go more than 10%, I'll put it this way. If you go beyond the word count, I then start to look critically to say whether you used your words efficiently. So if I see that you've written in an inefficient manner, and I will then say, well, you've gone over because you're not writing well, so you'll be marked down for that reason. And I'll be less likely to look critically at your work if you stay within the word count. I hope that makes sense. But if you're over by 10%, generally, I'm not going to be too concerned about it. For these first two assessment pieces in Introduction to Law, you don't really have to worry too much about the minimum. You don't really need to add value add. I won't use the word padded, I'll use value add. But generally speaking, for an assessment, I think you should be at least 75% of the word count and find something to add to it for the discussion. I hope that helps. All right, so presentation of your material is important, but it's got to reflect your basic way of doing things. So what are we looking for? Have a look at the basic skills referred to in The New Lawyer. And you'll find that there's some commentary there about basic skills, some commentary about planning your research, and some commentary about the way in which you should undertake the presentation. Think about the hierarchy, case law. So have a look at chapters 5, dealing with the sources of law in Australia, and then move on to chapter 6, which deals with legal research skills. So what you're putting together can be based on the content of the material in your text. For example, have a look at page 203 of your text, and you'll see that there's figure 6.1. It talks about a systematic approach to legal research. And that might be something that you wish to adopt, but I would be reluctant to encourage you simply to put that in to your toolkit because it may not work for you. I think it's very good, and there's nothing at all wrong with it, but I do encourage you to personalise this to the extent that you can. So in your textbook, you'll see there's some good commentary about the basic skills you need when it comes to legal research, planning your research, developing your own research strategy, and that usually means identifying the material facts, identifying the legal issues, and then once you've done that, then you can go on to consider locating the rules. And locating the rules might be primary, legislation or case law, or secondary, textbooks, legal dictionaries, things of that nature. But you've then got to apply the rules, which is the third part of IRARC. So you've got to interpret and then apply the rules to the facts. And the laws are not always simple. It's not always clear. And there may not be one correct answer. We've talked about legal research strategies and legal thinking last year. So it may be that in answering a question, you need to apply the rules by adopting reasoning by analogy. In other words, reasoning by analogy means that you're looking for similarities. In this case, the court determined this result, and the case that I'm now reviewing is similar. Therefore, by analogy, we could say that a court would likely adopt this approach in the current case. Or it might be that you apply your inductive reasoning technique to say, well, here's the specific principle. So from that, we can draw a more general approach that might be relevant to this case. So when you're doing your legal research, you're answering a legal problem. It's not just a matter of blindly following the rules, but you've got to apply the rules, and that's where your legal reasoning skills come into effect. I hope that makes sense.
John, I found it really interesting the other day. I was reading the case and the outcome, and I noted that there's no personal interpretation at all. So you can't go with what you feel whatsoever. And I just found that really interesting.
It is. There's always that personalised approach to it. And you see that with judges too. And as you become more experienced, you'll actually look for the judges that you like their style and their approach to it. But yes, no, you're right on track there, that there is a lot of subjectivity to this, which means you might think, oh, that makes it very confusing. I prefer to approach it, this is your opportunity to be very creative in your approach to the practice of law. So great observation. Thank you, Rhonda. All right, so what you need to do then is think about how to approach the law. And very importantly, if we're looking at IRARC, the issues, well, let's say MIRAC, so the material facts, the issues, applying the law, or the rules, applying the law, and then the conclusion. I do want you to state a conclusion. If you've got a legal problem and I ask you to provide advice to a client, what's the most important thing for a client? They want to know, what do you think? What is your conclusion? So likewise, in preparing a response to me, please state your conclusion. And that may mean that you justify your position. Again, you might be entirely different mindset to me, but you still might get full marks. So two people, this is not maths, two people may have completely opposite conclusions and yet both have top marks. So you can be a bit creative, and that gives you a bit of freedom then. But make sure that you make a call. You've got to give a conclusion on this. All right. AGLC, make sure that you know how to cite cases. So for example, the year will be in round brackets in some cases and square brackets in other cases. Have you noticed that already? Some cases, the year is in round brackets, other it's in square brackets. You might ask, why is that? Well, I'll leave you to find that out. If you have problems finding it, then ask through Q&A. All right, so question is, John, are you referring to a case here? Are you meaning for the take-home paper? Yes, I mean for the take-home paper for the purposes of this unit, but generally, of course, most of your assessment in law will be you being given a scenario, and then you have to answer the scenario. So what we're doing is we're building a mindset and a toolkit that will allow you to answer not just the question as it's likely to be for the briefing paper, the take-home paper, but more generally beyond that. I hope that answers the question. Okay, so when you start your research, you need to consider legislation. Always remember the Acts Interpretation Act may be relevant. You need to know how to note up pieces of legislation to look at relevant case law that is referred to by that legislation, or that refers to that legislation rather. You need to undertake search engines. Now, does anyone know what a Boolean search is? Anyone come across Boolean connectors? How to use them? Yes? Oh, good. We're getting a few. Tuna is onto it. Lock is onto it. Excellent. All right. And or not. Yes. So you make sure that you understand and practice these Boolean connectors. I'm going to give you an exercise here, and if I remember to do this, we might come back to it next week. What I'd like you to do is try to discover these words. Negligence, a Boolean is B-O-O-L-E-A-N. I do hope that's the correct spelling. Boolean. So try this. Within your favourite database, I want you to find some important cases that deal with the concepts of negligence and balcony and fall, F-A-L-L. So obviously, the factual scenario that you've got for your take-home paper, someone has fallen from a balcony, you're wondering whether it's negligence. So look at those three words, negligence and balcony and fall, and give me, maybe for next week, 3 or 4 cases that the most important on that topic. All right, so I won't do that now, but I'll ask you to do that during the week. So with your Boolean searches, you need to have an idea of how to use the word operators. And is one operator that you'll need for your search engine. Or is another one. Not, Emmanuel identified those. And or not. Near, another one is W/N, which is within the number of words of the second. So it might be, for example, court W/5 jurisdiction is an example search of that. I'll give you another piece of homework and then we'll wrap it up for tonight. So I'd like you to find section 754. I hope I've given you this already. 754 of the Police Powers and Responsibilities Act, and find a couple of relevant cases to that. That's a really basic search. Also, see if you can find section 24 of the Queensland Criminal Code and see if you can find some relevant cases to do with that. So you've got that. And the third is see if you can find the Australian Consumer Law and tell me what section 29 of the Australian Consumer Law is all about. We got that? So that's your in-class homework for next week. All good fun? All right. So this week you should definitely make some start on your toolkit if you haven't already done so. I think I've given you half a dozen tasks to complete as very soon in the next few days. And please look at that homework that I've given you for next week, and we'll go through the exercise next week during the session. Any questions? All good? All right. Well, we'll wrap it up for tonight. Thank you very much for your attendance. Sorry I talked so much, but you've all been very patient, and we'll see you next week. All the best.